Hello everyone, welcome to IS Baba's 60 days rapid revision series for Prelims 2022. This is day 14 and here again we are taking up polity. So we take up a blend of facts as well as concepts to be discussed. So these are the topics and we go with the first one, the types of majorities. So here the first comes absolute majority, that is the majority of total membership of that house. Say for example we have 545 members in Lok Sabha. So this is the number which is taken to calculate majority. So according to the 2/3 or half, so this number will be divided. So here don't confuse with the number 552. So which is the maximum strength. So 545 is the current one. And here during the impeachment of president, so such majority is being used. That is 2/3 of the total membership. And then we have effective. So here all the then members, that is inside the house. Okay, so whoever are members at that point of time, so that is the number which is used. And here the vacancies are deducted, but the absents, they are not deducted. Say for example, we have 10 seats in vacant in Rajya Sabha. So here 240 is the number which we are using. And if 5 members are absent, this number will not go to 235, it remains to 240. And such majority is used in the removal of vice president. That is 2/3 of the members, then members. So that is the majority for removal of vice president. And then we have simple majority. So that is the members present and voting. So half of the members who are present and voting. So this is used for enactment of any law, resolutions or others. And then we have some special majority. So this is 2/3 majority of the members present and voting. So this is used in Article 249 where a Rajya Sabha passes resolution for creation of All India Service and others. And then we have special majority as per the amendment of the constitution. So here we have the 2/3 majority who are present and voting, and that number should not be less than 50% of the total membership. Okay, so that is the number which we obtain by this 2/3 majority. So that should not be less than 50% of 545. So this 50% is stipulated so that we will not make 10 people to sit, and in that if 7-8 people vote, so we will not declare as the constitutional amendment. So to maintain the sacredity, we have kept this 50%. And then if there is any amendment, so which is related to federalism, so then minimum 50% of the states, so they should have this an enactment passed with simple majority. So this is related to federalism. So any federal clause, if we are amending in the constitution, so that comes with the original amendment procedures along with 50% of the states being ratified. And then coming to next, the power of speaker with respect to defection. So here any question regarding disqualification arising out of defection is to be decided by the presiding officer of the house. So president of the house. Then the decision of the presiding officer is subject to judicial review. Say for example in the Kyoto Olohan case. So here while deciding a question under the 10th schedule, the presiding officer should function as a tribunal. And hence his or her decision, like that of any other tribunal, was subject to judicial review on the grounds of malified intentions and perversity. So on these two conditions, a Supreme Court or a High Court, so they can take over the decisions of the speaker and then they can decide over the defection cases. Then there is no limit that the presiding officer will pass on a judgment. So he can sit on the judgment on how much time he can or how much time he wants. So this is the clause which the speakers are making use of right now. Say for example, if a person, if he is defecting from opposition to ruling party, so that will be in the advantage position for a speaker's party. So that's why no action will be taken on them. But if it is vice versa, if a person from ruling party, if he is defecting to opposition party, then speaker will take sudden actions. So such partiality, so that is the one which is disturbing the defection clauses right now. And then coming to next, the devices of parliamentary proceedings. That is, whenever parliament starts, first the question hour comes and then the 0 hour comes and then the agenda will be discussed. And after the agenda, the house will be closed. So house will be adjourned for that day. And here in the question hour, two types of question can be asked, a start question and an unstart question. So here a start question means that which requires oral answer. So whenever a minister is speaking orally, so he can be asked a supplementary question also. So he can answer that supplementary question as well. But in unstart question, a minister is giving a written reply. So he cannot write the written reply at that spot. So no supplementary questions for these. So however, whenever we are asking a question in the question hour, so you will have to give a 10 days notice. Okay. So 10 days notice has to be given in the house so that we are going to ask a question in question hour. but that is not the case in 0 hour. 0 hour without giving any notice. So you can stand up and ask a question. And this is not present in UK's parliament. This is India's innovation. So one question had come from this. So make sure that you will remember that. Okay. So here for the Rajya Sabha, the state starts with a 0 hour. Okay. And not the question hour as in the Lok Sabha. So it is like for Rajya Sabha, the day starts with the 0 hour and then the question hour and then the agenda. But however, various changes are going on in Rajya Sabha right now. So for some time, they have abolished the 0 hour completely. So if there are any updates in the future, so we will update accordingly. And then we have the motion of thanks. So whenever president, either for the fresh assembly which is elected or for the fresh house of the session, so if he addresses, so his address will be voted. So that is the motion of thanks that is given. So whenever a government is defeated in this motion of thanks, so then they lose the confidence and the confidence has to be proved in the house. And if they are failed, so then the government falls. And then the point of order, so point of order motion, so that is filed. So whenever the house is not going in order, so if a member feels that no one is following or any person is not following the rules of procedure of the house, so point of order motion can be claimed by him and he can raise this. Okay. So these are some of the proceedings that go in the parliament. And then we have the two kinds of financial bills. So here again, there are controversial debates that are going on, like what is that and what is this. So here we try to understand. So first we always know that the money bill. So money bill, it requires a prior permission of the president. Okay. So after that it will be submitted. It will be introduced only in the Lok Sabha, and once it is enacted, so but obvious president will give the assent. And what kinds of bill are the money bills? That is the bills which contain the imposition of tax, abolition of tax, then remission and alteration of the same tax, and which related to the matters of consolidated fund and provides for imposition of fines, etc. So all these will come under the money bill. But however, we have the financial bills. So here we have two kinds of financial bills. That is, first bill comes under Article 17 Clause 1. The second one, the Article 17 Clause 3. So here it is like the first type of financial bill can be introduced only in Lok Sabha and not in the Rajya Sabha, and can be introduced only on the recommendation of the president. So here this first type of bill is more like a money bill, because that is, it is having the provisions of Article 110, okay, and it also has other provisions also. So like it has some provisions which are present in the money bill also, but along with that it is having other provisions. Say for example, if there is a law, so that law also imposes some cess and surcharges. So that is imposition of tax. So such ones will become the financial bill 1. And then coming to financial bill 2, so they can be introduced in either house of the parliament, and the recommendation of president is not necessary for the introduction. So here they are bit diluted. They are not as strict, because here although it contains something regarding the money, but here it is like it contains only one clause, that is they are taking some money from Consolidated Fund of India. Say for example, we are launching MG Narega Act. So here nothing like the taxation, nothing like the fees, fines, nothing is provided. Only that it says that we are taking out some 60,000 rupees from Consolidated Fund of India. So such bills, they are not as financial bills. So it is the original bill, but only the money is showing that it is related to finance. So such ones, so they can be passed mostly like the ordinary bills. So they need not be going with the harsh procedures. So like ones. So here we can say that here we have some 50 or 60% of the money related ones in these bills, but here it has only one clause, that is withdrawing the money from the Consolidated Fund of India. So understand this. And then coming to next, the financial committees of the parliament. So here we have the Public Accounts Committee. Public Accounts Committee was established in 1921. So as per the Montagu-Chenford reforms of 1919, and composition of Public Accounts Committee currently, that is 15 members of Lok Sabha and 7 members from Rajya Sabha, totally adding up to 22 members. And chairman will be from the leader of opposition only. So to check and balance, so we have made a convention for appointing the chairman as the leader of opposition. So here election of members, that is by parliament, the members are elected every year with a proportional representation by means of single transferable vote. So just like the election of Rajya Sabha members, or just like the election of president, so here also with the proportional representation, the members to the Public Accounts Committee, they are being elected. and then a minister cannot be elected because this public accounts committee, so that looks into the CAG's report. So this is completely an accounting committee. So that is why the ministers will be held accountable. So they cannot hold accountable themselves. So they are barred. And then the term of office 1 year. So a member can be elected only for 1 year. Next year it is changed. Then the chairman. So speaker appoints him or her from amongst the members. So speaker can appoint anyone from the members. But invariably the leader of opposition will be there. Okay. So if leader of opposition is not willing, so but obvious others can be. And then we have estimates committee. So committee is elected every year from amongst the members of the House of the People according to the principle of proportional representation. So its membership was initially 25, but later it was increased to 30. So here it is like all members are from the Lok Sabha only. So here no one are from Rajya Sabha. So here it is like estimates committee means, so this committee will work before the passing of the budget and it will remain throughout the year into functioning, like how they are spending the estimated money, how much demands of grant the government is demanding. So throughout the year it will be keeping the account of the government's expenditure. But public accounts committee, that will come into picture only when the auditor's report, the CAG reports comes. That is, public accounts committee is more critical in its functioning compared to estimates committee. And then its chairman, that is the estimates committee's chairman, is appointed by the speaker, and if deputy speaker happens to be a member of committee, he automatically becomes the chairman. So deputy speaker is given the preference in making as a chairman. And then we have the Committee of Public Undertakings. So this committee was set up in 1964. It consists of 15 members, that is 10 from Lok Sabha and 5 from Rajya Sabha. So the function is to verify the audit papers of various PSUs to see whether the public sector undertakings are working properly or not. So revise it again and again. Public Accounts Committee, a very critical committee which looks into the CAG papers, and Estimates Committee which just sees how the government is spending and how the government is getting the income, and the Committee on Public Undertakings. So it is like to verifying the financial status of the PSUs. And then we have other parliamentary committees. So like we have the committees to inquire, that is Committee on Petitions. So if any petition is being filed in the Supreme Court or a High Court, so regarding any issues, so on which the parliament is also debated, or on which even the government is a party, so such ones, so the Committee on Petitions will revise. So if there is any mistake on the part of government, or if there is any mistake on the part of Council of Minister or any minister, so they will review and they will bring to the parliament and discuss them. And then the Committee on Privileges. So we have parliamentary privileges, that is both individual and group privileges. So that will be looked after by Committee on Privileges. Then Ethics Committee. So the Code of Ethics we have for all MPs. So that will be looked after by Ethics Committee. And then we have the committees to scrutinize and control, that is Committee on Government Assurances. So whenever a minister assures something or whenever a government assures something, so do they keep up those promises? That will be checked. Then Committee on Subordinate Legislation, that means what rules, policies they formed, so whether they are being fulfilled and whether they are being implemented, so that will be checked. And then Committee on Papers laid on the table. So whenever a policy is laid in the floor of the House, or whenever a law is introduced into the floor of the House, so that will be looked after by this committee. And then Committee on Welfare of SCs and STs. So but obvious, they look into the welfare of scheduled caste and scheduled tribes. And then Committee on Empowerment of Women, and then Joint Committee on Offices of Profit. So it will check whether any position it amounts to office of profit, or whether a person who is in office of profit, whether he can get elected to any committee or any other posts for that matter. So this basically decides the legality of an office of profit, so whether it is actually an office of profit or not. And then we have committees relating to the day-to-day business, that is Business Advisory Committee. So it advises the day-to-day. So here for the Business Advisory Committee, so most probably the speaker, so he will be the chairman. Then Committee on Private Members Bill and Resolutions, so here also. And Rules Committee, so the implementation of the rules of the House, so here also most probably the speaker, he will be the chairperson. And then Committee on Absence of Members from sitting the House, so it is like whoever are absent, so what action should be taken on them. And then Housekeeping, so General Purposes Committee, like any other the normal maintenance. Then House Committee, So House Committee means the accommodation facilities and others for the MPs. Library Committee say the same library facilities, and then Joint Committee on salaries and allowances. So if there is any hike in salaries, so this is the committee that reviews those bills. And then we have suspension of MPs. So recently we have seen suspensions of various MPs in the House. So it is the role and duty of the presiding officer, that is the Speaker of Lok Sabha and Chairman of Rajya Sabha, to maintain order inside the House. So the rule number 373 of the Rules of Procedures and the conduct of business, so that provides for suspension of MPs by the Speaker of the House. And then to deal with the more recalcitrant MPs, the Speaker may take recourse to the Rule 374 and 374A. So what this 374 says, the Speaker may, if deems it necessary, name a member who disregards the authority of the chair or abuses the rule of the House by persistently and willfully obstructing the business thereof. And for them, they can skirt around. So skirt around means they can suspend, or they can forcefully send him out, or they can call the security guards and ask them to take him out. Okay, and any other necessary punishments, so that can be given who will obstruct. So as per 373 and 374A, so it only says that we can either suspend an MP, you can ask a security guard to take him out, or you can levy some fines. So all these things, so these are present in the Rules of Procedures of Lok Sabha. So they are not present in any of the constitution or any other articles. So okay, so such thought process also you will spend here. And then we have MPLADS scheme. So MPLADS scheme, so that was cancelled, and now there are debates of that coming again. So in that context we discuss. So this was launched in 1993, and the scheme provides each MP with the choice to suggest to the district collectors for works to the tune of 5 crores per annum to be taken up in his or her constituencies. Okay, the objective is to create durable community assets for the provision of basic facilities. Okay, so with this good intent, so some 5 crore of money is given to the MPs every year. And here the UPSC asked a question like, this amount cannot be renewed every year. So why it can't be renewed? See friends, when crores and crores of monies are being unspent by various departments, so what wrong does an MP does if he uses that money for any good purposes the next year? So that is a progressive clause. So go and hit it as a correct statement if such statements come, or if it is in negative, like if we cannot use, so go and put it as a wrong statement. Then there is a special focus on the areas inhabited by the scheduled caste and scheduled tribes. So some percentage should be earmarked for these people. So but obvious, the social justice prompts them. Then there is a ceiling of 50 lakhs that can be spent from the MPLADS fund for the work of a particular society or trust in his lifetime. So for example, for one trust, so maximum he can give 50 lakh rupee. It is not like all the 5 crores he will give for one society. So there are chances of corruption and there are chances of benami assets. So that is why this 50 lakh bar. And then we have the Ministry of Statistics and Program Implementation is the nodal department responsible for the policy formulation and release of funds under MPLADS scheme. Then the state nodal departments are responsible for supervision and monitoring. Then the district authorities, they are responsible for the work scrutiny, cost estimation, identification of implementing agencies and transfer of funds. Then the scheme mandates Panchayati Raj institutions to be preferred as implementing agencies. So starting from central, state, then district and local administration. So all are involved in this MPLADS scheme. And then we have the lapse of a bill. So how a bill lapse? Say for example, a bill pending in Lok Sabha. So that will lapse. Okay, and then a bill passed by the Lok Sabha but pending in Rajya Sabha. So this also lapses. So here, say for example, you imagine this as a sinking boat. So Lok Sabha is a sinking boat because after 5 years, this Lok Sabha will sink. So new Lok Sabha will come. So whichever papers that are present on this boat or the sinking ship, so that will lapse. Say for example, here a bill is pending in Lok Sabha. So but obviously it is in this sinking ship, it will sink. Then a bill passed by Lok Sabha. So here it is like the bill hasn't gone to Rajya Sabha yet. So here it is pending. So that is why although it is passed, it will again sink. Then a bill not passed by the two houses due to disagreement, and if the president has notified that a joint sitting has to be there. So this doesn't lapse because so now the bill came out and now it is in the president's custody. President has taken it out. So even if the ship sinks or the boat sinks, so president will be having one copy in his office. And then a bill pending in Rajya Sabha but not passed by Lok Sabha. So Rajya Sabha is not a sinking ship. So whatever bills that are present in Rajya Sabha, they will never lapse. And then a bill passed by both the houses but pending assent of the president. So both have passed. So now the bill is in president's office. So president's office will never sink. So that bill will not lapse. Then a bill passed by both houses but returned by the president for reconsideration of the houses. So here also again, so whenever president is sending back, so but obvious one copy will be there with the president. So again it will not lapse. Okay, so here only two cases where the ship is sinking, that is if a bill is pending in Lok Sabha and if a bill is passed in Lok Sabha only. So remember these two statements, that is more than sufficient. Then private members bill, a bill introduced by MP who is not a minister, that is a non-government member, so that becomes a member's bill, but obviously a simple concept. And then however, a private member can give a maximum of 3 notices for the introduction of a private member's bill during one session. So mark these 3 notices. Okay, so it is not like every time you will come up with one new private member's bill. Then members of parliament of both the ruling party as well as the opposition can introduce a private member bill. So a MP means he need not be from opposition only. So even if he is from ruling party, if he feels that so his advisors are not being taken by the Council of Ministers, so he can raise the awareness by bringing a private member's bill. Then such bills can be introduced and discussed only on Fridays. So this is written in the rules of procedures. Then the admissibility is decided by the chairman of Rajya Sabha and speaker. So whether to admit it or not, so that is the prerogative of the speaker and the chairman. And then the member must give at least 1 month's notice before the bill can be listed for introduction. So mark this 1 month notice. Say the latest private member bill, that is the Unemployment Allowance Bill 2019, that sought to provide an allowance to all unemployed people. So these are some of the facts regarding private members bill. And then we have the charged expenditure on Consolidated Fund of India. So a brief revision on which are the expenditures which are charged on the CFI. The first is the expenditure of the Supreme Court and High Court. So but obvious, the judiciary should be independent. And then salaries, emoluments and pensions of the judges of Supreme Court, again independence of judiciary. Then salary and emoluments of president, so that president should be well above the executive. So president should not be blackmailed and controlled in the name of deduction of salaries. And then we have vice president and deputy chairpersons. So even they are well above the executive. And then speaker and deputy speakers, so they come along with them. Then CAG and UPSC, so these are constitutional bodies. So government cannot harass them by saying that I will deduct your salary. Then interest and other debt related charges of the government. So this is an international obligation. If the government has taken some debt, so they will have to repay it at any cost. So they cannot wait for the house to vote for that. And then any sums required to satisfy any court judgment pertaining to the government. So when judicial judgment comes, so but obvious that becomes the foremost duty of the government. And then salary of High Court judges is charged on the Consolidated Fund of States. So here whenever a judge in the High Court he is serving, so he will be serving that state. So that's why that becomes the prerogative of the Consolidated Fund of States. But if he retires, so he might be working in 3 to 4 states before retirement. So now which state will give? So now it is a confusion. So that is why to avoid such confusion, so it is like no state will give a pension. So only the central government from Consolidated Fund of India, they will give the pension. So pension from CFI, the salary from the state consolidated funds. Then different motions of parliament. So main motions, that is they are the propositions before the assembly for consideration. So to make sure that the house will consider any important topic. So only one main motion can be considered at a given time by the assembly. So when the speaker gives a time, only one motion can be considered. Then subsidiary motion, that is modification or disposition of the main motion. So when the main topic is going on, so subsidiary motion means so they are adding one or they are removing a clause. So likewise, then incidental motion. So if there are any incidental ones, say for example, if the fisherman issue is going on, so a bottom trawling can be incidental motion. Then the privilege motion, that is breach of privileges. Say for example here, when a person has breached the privilege of the parliament, say for example, if a person is speaking derogative of the parliament, so now the breach of privilege motion can be. Then censure motion. So if a person he is censuring or he is humiliating the government, say for example, if a minister is speaking lies or he is giving a wrong data, so now the censure motion can be called into picture. Okay, so privilege. So this comes with specific clauses where the privilege is applicable, and censure is a broader clause. So for any derogatory remarks, you can bring in censure motions. And then call attention motion. So call attention means, so we are calling the attention of the speaker for any of the important topics that are going on. And adjournment motion. So whenever the speaker wants some time to fix another time, or maybe whenever the time is up, so it is like the temporary halt that is given. So adjournment means, so but obvious the word itself explains, we are adjourning the things for the next meeting. And then not day yet named motion. So whenever adjournment occurs, so it is like the speaker says that this agenda will be taken up any other day. So if that other day is not yet fixed, so but obvious here not at a day named motion, so that can be passed inside the house. So now speaker will be in an obligation to fix the day. So it is a request for the speaker to fix one day for the discussion. Then cut motions. So we have the policy cut, token cut and economic cut motions during the passage of budget. And then comes the no confidence motion. But obvious if the no confidence motion comes, so the government has to prove its majority in the floor. And this happens only in Lok Sabha. It doesn't happen in Rajya Sabha. Then leader of opposition in India. So leader of opposition is the leader of largest party, and that has not less than 1/10 of the total strength of the house. So recently the Congress government didn't get this 10% and they were not declared as the leader of opposition. Then it is a statutory post defined in the salaries and allowances of leaders of opposition in the Parliament Act 1977. So it is not a constitutional post, it is a statutory post. So mark it as important. Then the 10% rule was in fact brought in 1985 by the then Lok Sabha Speaker, that is Balram Jakkar, to deny the position to a party from the then Andhra Pradesh. So basically TDP party. So to deny that, so it was being brought. So these are the political issues. So not so important for us. Now, for what purposes the leader of opposition is important? So apart from the checks and balance he does, so he is involved in the appointment of various posts. Say for example for CVC, we have Prime Minister, Home Minister and leader of opposition in Lok Sabha. Then for CIC, so CVC means Central Vigilance Commissioner. Then CIC means Central the Information Commission. So PM, any union minister and the leader of opposition in Lok Sabha. And then we have NHRC. So for NHRC we have so many, that is PM, Home Minister, Speaker of Lok Sabha, then Deputy Chairman of Rajya Sabha, then leader of opposition of Lok Sabha and Rajya Sabha both. And then Lokpal, Prime Minister, CJI, the Chief Justice of India, Speaker of Lok Sabha, then leader of opposition in Lok Sabha and any other eminent jurist. So here in all these, the leader of opposition is involved. So mark these and revise. And then we have the model code of conduct. So elections went on in so many states this year. So here what is a model code of conduct? So it is not a law. So it is just an agreement that was attained by the election commission with all the parties. So all the parties, they came together and they have agreed that. And Kerala was the first state to adopt a conduct for the elections in 1960 assembly elections. And then in 1974, Election Commission issued a formal model code of conduct. So remember the dates and remember the state, because even in the last year, so some questions came from the elections. And then what does the model code of conduct contain? So a brief revision. So part 1, so that deals with the general percepts of good behavior expected from the candidates and political parties. Okay, so like what good behaviors they should have. They should not comment on the personal things of others. They should not indulge in any religious polarizations and others. Then part 2 and 3. So that will focus on public meetings and processions. So how healthy a meeting should be. So till what time to what time the meetings can be held. And then part 4 and part 5, they describe how political parties and candidates should conduct themselves on the day of polling and at the polling booths. So can they enter into all the polling booths, or can they influence the people there? Can they give a speech there? So all those. Then part 6 about authority appointed by the election commission to receive complaints on the violation of model code of conduct. So who is the authority to receive the complaint? What are his powers? And then the part 7 about the political party in power. So how the political party in power should behave. That is, once the election notification comes, that means the election commission will announce the date. So from then on, the model code of conduct will come into picture. So now when the model code of conduct is there, so all the MPs and MLAs who are in the ruling party, so they should hand over the government offices, they should hand over the government vehicles and they should go back and they should contest the election just like any other contestant who is contesting. And then part 8, manifestos must be pursuant to the directions of the Supreme Court. So Supreme Court has given various directions. So on those, the manifestos should be there. So we should not give false promises. We should not give any religious polarized promises or nothing of such sorts of partisan partiality should happen there. And then we have anticipatory bail. So here the section 438 of Criminal Procedure Code, so that deals with the anticipatory bail. That is, this provision allows for a person to seek bail in anticipation of an arrest on accusation of having committed a non-bailable offense. So here we discuss a brief about the concept of this bailable and non-bailable. See friends, basically the bail is a fundamental right. So everyone has the right to get a bail. Okay. So even for the non-bailable offenses, so we have the right to take bail. So how this works? Say for example, you are arrested in the bailable offense. So you will get that bail in the station itself, in the police station itself. If you keep some deposit and if you have some surety from your friends, so you will get the bail from police station if you are arrested on a bailable offense. And now if you are arrested on a non-bailable offense, so but obvious you will not be given bail in the police station. But when the court goes, so when the case goes to the court, so there inside the court of law, you can take the bail even for non-bailable offenses. So court has the authority to give bail for all offenses. So here the court bail, so this is universal in nature. It can be given even for the non-bailable offenses. Okay. So here we have some of the offenses. One is the non-cognizable offenses. Non-cognizable offenses means that which is not serious and the executive need not take it so seriously. Okay. So here it is like some petty cases and others. They come under this non-cognizable. Then cognizable offenses means some serious offense which the state has to take it seriously. And cognizable non-bailable means it is very serious one and no bail should be given at the station. And then compoundable offense. So compoundable offense means again simple offenses where the victim can pardon. So a dispute settlement can happen there. And remember, the station bails are available only for the bailable offenses, but the court bails are available for even the non-bailable offenses. So these are some of the ones which we have to discuss. And coming to the last part, friends, see, whenever we love the people, so we will love them once we start loving our surrounding ones. So we cannot expect you as bureaucrats to sit into that chamber, to sit into that AC room and then start serving the people. So charity always begins at home. So love your nearby ones. So love the rickshawala who takes you to the class. So love your cook, love your maid. So all this comes, and once you are loving a people with the open heart, with a pure heart, so it doesn't take much time for the people to realize that there is one person, there is one man or woman who is really loving us from the bottom of the heart. And but obvious, they will give hundreds and hundreds of love back to you, and you will be in that satisfactory position even if you succeed or fail in any of the exams for that matter. Okay, so make sure that you will study in that perspective. You expand your brain. So don't hanker for luxuries and don't try to become bureaucrats to enjoy those luxuries. So do it. All the very best. Good luck, friends.